You can be arrested in Texas right now for certain actions that the U.S. Supreme Court has already ruled are completely legal. Here's the part that might concern you. Those laws have not been repealed. They haven't been removed. Those laws are still on the books. That means if the courts change their mind, those laws can come back overnight. And that's not hypothetical. It already happened. I'm Matthew Harris, a board-certified attorney in Texas. I'm going to show you 3 real Texas laws that still exist today, even though courts have ruled them unconstitutional. And then I'm going to explain how that could directly affect you. Texas Penal Code Section 2106 still says that it is a crime for 2 people of the same sex to engage in deviant sexual conduct. That's not historical, that's current black-letter law. There have been efforts to repeal this law, even as recently as 2023, but those efforts failed, and this law remains on the books. How big of a crime is this? It's a Class C misdemeanor, the same as a speeding ticket. But here's the controlling case. In 2003, the United States Supreme Court held that this law violates the Due Process Clause of the 14th Amendment. In plain terms, the court held that the government cannot criminalize private conduct between consenting adults. So here's the contrast. The statute says it's illegal. The Constitution says it's not. And when those two conflict, the Constitution wins. So as of today, this law is still written, but completely unenforceable. Texas also has a law that makes it a crime to damage, deface, mutilate, or burn the American flag, as well as the Texas flag. How serious is this crime? Well, the punishment includes up to 1 year in jail and a $2,000 fine, the highest non-felony punishment. Obviously, most of us find this conduct to be utterly offensive. That leads us to Texas v. Johnson. In 1989, the U.S. Supreme Court ruled that flag burning is protected speech under the First Amendment. Now think about that for a second. Most people assume offensive conduct can be banned, but the court said the exact opposite. The more offensive the speech, the more protection it gets. So again, here's your contrast. What people think the law should be versus what the Constitution actually allows. And once again, the statute may exist in form, but it has no legal force. Now here's one most people don't even know exists. Texas law actually prohibits the sale, advertisement, or even lending of what it calls obscene devices. What's an obscene device? What's a family-friendly way to say this? Let's go with adult toy, intimacy aid, or marital device. And FYI, the law actually says that a person who possesses 6 or more obscene devices is presumed to have the intent to sell them. That statute was challenged in Reliable Consultants v. Earl. In 2008, the Federal Fifth Circuit held that the law violates the constitutional right to privacy. Same principle as Lawrence v. Texas. The government does not get to regulate private, intimate decisions between consenting adults. However, since this case was not appealed to the U.S. Supreme Court, this precedent isn't binding on Texas state courts, though it is binding on federal courts. So, this law could technically still be enforced, even though it rarely is. Now, up to this point, you might be thinking, okay, so what? These laws are dead, they don't matter. That assumption is exactly where people get caught off guard, because the next example proves the opposite. Texas had anti-abortion laws on the books for 100 years that criminalized elective abortions, abortions that weren't necessary to protect the life of the mother. Those laws were struck down in 1973 with the U.S. Supreme Court decisions in Roe v. Wade. For nearly 50 years after Roe v. Wade, those statutes were unenforceable. They stayed in the code, but had no legal effect. Then came the Dobbs decision in 2022. The Supreme Court overturned Roe, and when that happened, those previously dead statutes didn't need to be rewritten. They didn't need to be repassed. They were already there. They just became enforceable again. That is the system. Courts do not erase laws, they only pause them. So here's the reality you need to understand. There is a difference between a law being unconstitutional and a law being gone. Unconstitutional means not enforceable today. Gone means a court decision can't bring it back overnight. And in Texas, many laws are not gone. They're waiting. And if you want to understand how the law actually works, then like this video so YouTube will show you more videos like this. And if you subscribe, you'll see the new videos we publish every Thursday. For example, I think you'll enjoy this video right here if you don't mind listening to me for just a couple more minutes. I'll see you in the next video.